are some of the common mistakes you see people make when they come to you? People don't come to you, I don't think, initially as often as they should preventively. I'm sure you get people come to you and have a problem many times. What is the most common problem that people come to you with that you think would be preventable?
Well, that's, I'm glad you asked me that. And I'm going to amend that a little bit in order to dovetail into my agenda, which is not diverting from your question at all, but it fits into something I wanted to say. Today, TikTok is really big, as you know, and one of the current trends on TikTok is when professionals or persons who are in business say the top 5 things they wouldn't do, in their opinion, as a person working in that business. So a medical doctor, a brain surgeon says 5 things I would not do based on my experience as a brain surgeon, or for a who was the other day? 5 things I would not do from a person who's a real estate broker or whatever thing. So I wrote down 5 things that I would not do, as a person well-versed in the field of estate planning. 5 things. And so you asked me about what are the common pitfalls or mistakes or problems. I wrote these down right before our meeting. But first of all, and I'll just go through these real quick. Don't die with the child owing you money, because when you die, everything that you own passes to your children in equal shares in the main. And everything that you own includes the debt that one child owed to you. So now that debtor child becomes a debtor to his siblings or her siblings. And those siblings are going to want that debtor sibling to pay up, and there goes the family relationship. So don't die with the child owing you money. The second thing I wouldn't do is don't name just one of your children as the successor trustees of your living trust. The successor trustee's job, pretty much everybody's watching this has a living trust. The living trust provides that after you die, your children will come in and they will succeed you as your successor trustee to be the delivery boy of the assets that are in the trust to the beneficiaries who are set forth in your inheritance instructions in your living trust. And if you have 3 kids, your inclination is to say, too many cooks spoil the broth. I'm just going to name one of my children to be the delivery boy trustee to carry out my inheritance instructions. Well, I have learned that that's not the way to go. Efficiency does not always mean efficiency, especially in such an emotionally fraught arena as the inheritance arena. Because if you just name one child out of 3 children to carry out your instructions, well, those cutout children may think, hey, mom and dad didn't think we were smart enough or to do the job, or that they didn't trust us enough to do the job, even if that was not in mom and dad's mindset. They're just thinking efficiency. Or the children out of power often contest the job that the trustee child is doing. Hey, I haven't heard from that kid in a while. Haven't heard from our sister or brother in a while. What's he or she doing? And, gee, what is he charging for his fees? And, whatever it is, it's unfair. And what attorneys are being hired? What accountants are being hired? What tax positions is he taking? Are they disadvantageous to us? There's just a whole bunch of, there's just a whole bunch of things that the successor trustee has to do in order for a smooth transition of wealth from one generation to the next. And if all the children, all the siblings are not involved in that, then that could run into some big time problems, especially if there is a vacuum of information. Because when you have silence, when you have a vacuum of information, then what's going to fill that vacuum? It's going to be suspicion. So don't, so appoint all your kids as trustees of your trust, unless there's a good reason not to. One kid's on drugs, one kid you haven't talked to in 20 years. Okay, the next thing that I wouldn't do as an estate planning attorney advising a client is don't leave your children an unequal inheritance. Do not leave your children don't treat them unfairly. And unfairly to your kids means unequal. All right, well, that's easy. You know, you say, okay, I'm going to leave my kids everything I have, 1/3, 1/3, 1/3. Okay, 3 kids, fine. You think that's equal, but equal does not necessarily mean fair if you, mom or dad, gave more to some children during your life and less to the child who has gotten the short end of the stick. From a parent's perspective, you know, why should they care about that? They were helping a child out during their lives when that child needed help, financial help to start the business, you know, put the down payment on the home, you know, help their kid out with braces, pay for that wedding, whatever. You know, the parents are saying, hey, we're helping out the kids when they need that help, and they're not keeping a scorecard. But the ones who are keeping a scorecard are all the kids. And if those children are not given the additional funds to make up for the gifts that the others got, then they perceive that they've been treated unfairly, and they're going to keep that in mind as they progress in life with their relationship with their siblings. I understand. I'm the first person to understand that parents really don't need to keep track of all the lifetime gifts they made to all their children. But my advice is, based on everything that I've seen and all the fallout that I've seen after parents die and children divide the money, that the parents should at least consider equalizing gifts that the parents made to more children than the others over their lifetime. Because if you don't, then it's quite possible that your children, who are the most precious possessions in your life, and you want to be sure to have a good relationship after you die, do not split up over this perceived unequal inheritance. So that's 3 things, Bill, 3 things of don'ts, you know, and these are the biggest problems that I see in the inheritance plan. Just 2 more. I know I'm going on this soliloquy, but you got me started. So now you're going to regret your decision. 2 more. Don't allow your children to blow the dough. Don't leave them their inheritance in such a way that they will be in a position to, you know, throw it in the street or lose it in a divorce, or, you know, it all winds up with their you know, your son's widow's second husband's kids from his first marriage. You have to understand that when you leave your assets to your children, it becomes theirs. They can do whatever they want with it, but they can also lose it to all the risks in their life. So the parents have to account, you know, and they have to, you know, examine who are their kids. Are their kids responsible? Or do they have financial maturity? Are they in a business where there is a high malpractice litigation rate? So we take that information and we say, okay, maybe it's your children should receive it in a way that protects it from those potential risks of loss. Okay. And the last one is, don't have an inheritance plan that allows more of what you own to go to the IRS than your children or grandchildren. And that's the topic of estate tax planning. Maybe not so relevant right now for most people who are listening to this or watching this, because right now there's an exemption from the estate tax of 12 million, which means you can die with 12 million, with less than 12 million and not your kids don't have to pay any estate tax. But that 12 million exemption goes back down to 5 million in 2025 or 6. The estate tax exemption is a political football. It's changed with every single presidential administration since Bush in 2000. It's the biggest political football I've ever seen. I've never known another tax or other law that has changed every single time there's a new administration. Yeah. So who knows, if you vote Republican in 2020, you know, in November, maybe we won't have any estate tax, and therefore, you know, exemption doesn't apply. But, you know, chances are we'll still have a $5 million estate tax exemption. And if you die with less than 5 million, there will be no estate tax. But if you have more than 5 million, which is easy to do in Southern California with real estate values so crazy, then yeah, there are plans that we can be put in place where more or all of what you own goes to your children, grandchildren, and less to the IRS. Okay, now I'll shut up. And I'll let Snoopy do the talking. Snoopy has got a few things to say.